Understanding the evolving landscape of firearms law in the United States is not merely a matter of political curiosity for millions of law-abiding citizens. It is a crucial component of responsible citizenship. The legal framework governing who can own, carry, and use firearms is in a constant state of flux, shaped by new legislation, federal regulatory changes, and, most importantly, ongoing interpretation by the judicial system. Staying informed about these changes is essential to ensure that your conduct remains within the bounds of the law, as ignorance of the law, as the old adage goes, is no excuse. With several significant legal developments unfolding in 2026, from Supreme Court decisions to new state statutes and federal rule changes, the need for clear, factual, and balanced information has never been greater. How familiar are you with the specific prohibitions that could apply to you or someone you know? And do you understand the legal tests that courts are now using to determine the constitutionality of gun laws? To understand the current legal environment, one must first appreciate the foundational constitutional principles at play. The Second Amendment to the U.S. Constitution, ratified in 1791, states simply, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." For nearly 2 centuries, the precise meaning of this amendment was the subject of significant legal debate. That changed dramatically in 2008 with the Supreme Court's landmark decision in District of Columbia v. Heller, which firmly established that the Second Amendment protects an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home. This decision was expanded upon in 2010 in McDonald v. City of Chicago, which applied this interpretation to the states, meaning that state and local governments are also bound by the Second Amendment. The most recent seismic shift in Second Amendment jurisprudence came in 2022 with New York State Rifle and Pistol Association Incorporated v. Bruen. In Bruen, the Supreme Court struck down New York's may-issue concealed carry regime and, in doing so, articulated a new, stringent test for evaluating gun laws. The court held that when the plain text of the Second Amendment covers an individual's conduct, the Constitution presumptively protects that conduct. To justify a regulation, the government cannot simply point to an important public interest, like public safety. Instead, the government must affirmatively demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. This text, history, and tradition test has become the central framework for every major Second Amendment challenge in the country, forcing courts to delve deep into historical records to determine if modern laws have proper historical analogs from the founding era or the Reconstruction period. It is within this post-Bruen legal landscape that the phrase gun confiscation often arises, frequently in heated political rhetoric. However, as a legal educator, it is my responsibility to frame this discussion not in terms of sensationalism, but in terms of precise legal categories: disarmament, forfeiture, and the expansion of prohibited classes. The title of this article, Lawyer, New Gun Confiscation Plans Incoming, demands a careful examination of what these plans actually are in a legal sense. Are we talking about the government going door to door, seizing lawfully owned property? Generally, no. Instead, we are talking about laws and regulations that create new criteria for who is legally allowed to possess a firearm. When an individual falls into a newly defined prohibited category, they are legally required to dispose of their firearms by selling them to a licensed dealer, transferring them to a person who is not prohibited, or surrendering them to law enforcement. Failure to do so results in the commission of a new crime, possession of a firearm by a prohibited person. This is the mechanism by which legal ownership is extinguished, and while it may not fit the colloquial image of confiscation, its effect is the disarmament of specific individuals. Several significant legal actions in early 2026 perfectly illustrate this process. One of the most impactful changes comes not from Congress or a state legislature, but from a federal administrative agency. On January 22, 2026, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, published an interim final rule that significantly revises the regulatory definition of who qualifies as an unlawful user of or addicted to any controlled substance. To understand why this is so significant, we must look at the underlying statute, 18 U.S.C. 922 G. 3, which makes it unlawful for any person who is an unlawful user of or addicted to any controlled substance to possess firearms or ammunition. For decades, ATF regulations at 27 CFR 478.11 provided specific inference examples to help determine current use. These examples allowed an inference of current use based on a conviction for drug use or possession within the past year, multiple drug-related arrests within the past 5 years if the most recent was within the past year, or a positive drug test within the past year. Under this old framework, the National Instant Criminal Background Check System, NICS, would deny a firearm transfer to an individual who had, for example, a single admission of drug use or a single positive drug test in the previous 12 months. In fiscal year 2025, this resulted in approximately 9,163 NICS denials based on the unlawful user prohibitor. However, a significant disconnect had arisen between these administrative denials, ATF's enforcement practices, and prevailing court decisions. Federal courts, including the 4th, 6th, 7th, 8th, and 10th circuits, had consistently held that to be an unlawful user, an individual must be a regular unlawful user at or around the time of possession, and that a single, isolated instance was legally insufficient. ATF field offices, in coordination with U.S. attorneys, were rarely prosecuting cases based solely on a single-use inference because they could not meet this judicial standard of proof. Of the 9,163 denials in FY25, ATF did not even refer 8,893 for further investigation, acknowledging the legal insufficiency of the basis for the denial. The new ATF rule, effective immediately as of January 22, 2026, directly addresses this disconnect by removing the specific inference examples from the regulation. The updated definition now requires evidence of a pattern of use that indicates the individual is a current unlawful user, rather than relying on a single event within the past year. The ATF explicitly stated that retaining the old inference examples was inappropriate because they resulted in denied transactions inconsistent with the prevailing interpretation of the law and created unnecessary constitutional questions. This change means that a person who can demonstrate they have ceased any unlawful use and are not currently engaged in a pattern of use may no longer be automatically prohibited based on a past, isolated incident. While this may seem like a loosening of restrictions, it is crucial to understand the legal philosophy behind it. The ATF is aligning its administrative rule with the judicial interpretation of the statute to ensure that denials are legally defensible. This action reduces the likelihood of erroneous denials and strengthens the overall integrity of the background check system. For gun owners, this highlights the critical importance of understanding that use, in the legal sense, is a question of current, habitual behavior, not a permanent ban based on a single mistake, provided that mistake is not part of an ongoing pattern. While the federal government refines its definitions, state legislatures across the country are actively considering and passing a wide array of bills that directly impact gun owners. Far from being a monolithic movement, the legislative landscape is a patchwork of conflicting approaches. In February 2026, the Alaska Senate considered SB 203, a bill that would expand state restrictions on devices that allow a handgun to fire more than one round per trigger pull, potentially going beyond existing federal law and creating complications for individuals who legally possess such parts. In Colorado, lawmakers have introduced a series of stringent measures. Senate Bill 26-043, which has already been heard in committee, would require all firearm barrels to be sold or transferred in person through a federal firearms licensee, FFL, effectively establishing a de facto registry of barrel owners, as FFLs would be mandated to keep records of these sales for at least 5 years. Meanwhile, the Colorado House Judiciary Committee is reviewing bills on both ends of the spectrum, including HB 26-1021, the Second Amendment Protection Act, which seeks to repeal many of the state's existing gun laws, including waiting periods, age restrictions, and bans on carrying in certain public places, while also reasserting state preemption over local ordinances. Other states are moving in different directions. In Mississippi, SB 2339 seeks to align state law more closely with the federal Lautenberg Amendment by allowing courts to order the removal of firearms from respondents to domestic abuse protection orders upon a finding that possession poses a risk. This is a classic example of expanding a prohibited class. Individuals who were previously allowed to possess firearms under state law may now be subject to court-ordered disarmament for the duration of the order. Vermont has introduced H606, a wide-ranging bill that would expand the prohibited persons list to include individuals receiving outpatient mental health treatment, a category that is not currently prohibited under federal law. This bill also proposes to ban rapid-fire devices in a way that critics argue is overly vague and could apply to commercially available accessories, and it would create a state-level cause of action to sue gun manufacturers, effectively circumventing the Federal Protection of Lawful Commerce in Arms Act. In Virginia, HB 1524, which would prohibit the carrying of loosely defined assault weapons in public, has advanced in the legislature. Illinois continues to refine its regulatory framework with bills like SB 0008, the Safe Gun Storage Act, which imposes civil penalties on firearm owners if a minor, an at-risk person, or a prohibited person gains access to an unsecured firearm, establishing a new legal duty of care with fines escalating to $10,000 if the firearm is used in a crime or to cause injury. This flurry of legislative activity at the state level demonstrates a fundamental reality: the definition of who can own a gun, where they can carry it, and how they must store it is becoming increasingly localized. For a gun owner who moves from South Dakota, where Governor Larry Roden recently signed a bill removing suppressors from the state's controlled weapons list, to a state like California, the change in legal obligations is staggering. California, for instance, is considering bills like SB 948, which would dramatically increase the requirements for a firearm safety certificate, mandating 8 hours of state-approved training, including live-fire exercises, and requiring new residents to report their firearms to the Department of Justice within 60 days. This creates a significant legal trap for the uninformed. A person who lawfully possessed a firearm in their previous state may become a prohibited person in their new state simply by failing to comply with registration or training requirements within a statutory deadline. This is not confiscation by warrant, but it is disarmament by operation of law, a consequence of failing to navigate a complex web of state-specific regulations. Parallel to these legislative actions, the federal judiciary is actively shaping the Second Amendment through precedent-setting cases. The Supreme Court's 2026 docket includes 2 cases that will provide further clarity on the Bruen text, history, and tradition test. In Wolford versus Lopez, the court is considering a challenge to Hawaii's law that presumptively prohibits carrying handguns on private property open to the public unless the property owner has affirmatively consented, a law opponents have dubbed the vampire rule. During oral arguments in January, several justices appeared skeptical of the law, questioning the historical basis for such a restriction and drawing parallels to hypotheticals involving other constitutional rights. Justice Kavanaugh noted that the Heller decision provides exceptions rooted in history, but questioned whether sufficient history existed to support Hawaii's regulation. Justice Alito pointedly questioned the use of a racially motivated 1865 Louisiana law, part of the Black Codes designed to disarm freedmen, as a historical analog to justify the modern Hawaii law, asking if it was the height of irony to cite such a law. The outcome of this case will have profound implications for this sensitive places doctrine, potentially determining whether states can create expansive default bans on carry in privately owned but publicly accessible locations like shopping centers, grocery stores, and banks. The second major case, United States versus Hemani, directly addresses the constitutionality of the same federal statute at issue in the ATF rule change. 18 U.S.C. 922 G3, the ban on firearm possession by unlawful drug users. Ali Hemani challenged his prosecution under this law, arguing that the historical tradition at the founding only disarmed individuals who were currently intoxicated or under the influence, not those who were merely users or addicts, who might be sober at the time of possession. The government, supported by historians, presented evidence of numerous early American laws that disarmed habitual drunkards, and those who might pose a danger to the public, not just those actively drinking. The outcome of Hemani will likely determine whether the federal ban on drug users is constitutionally sound, based on the historical record and the court's recent decision in United States v. Rahimi, which upheld the disarmament of individuals subject to domestic violence restraining orders. Many legal observers predict the court will uphold the law, finding a sufficient historical tradition of disarming individuals whose chronic substance abuse renders them potentially dangerous. Beyond these headline-grabbing Supreme Court cases, federal appeals courts are wrestling with other fundamental questions. The Third Circuit, for instance, is considering challenges to New Jersey's ban on assault weapons and its restrictions on carry in sensitive places. Legal experts suggest that the Third Circuit, with its recently changed composition, could become the first federal appellate court to strike down an assault weapons ban post-Bruen, setting up a likely future Supreme Court showdown. Other circuits are grappling with the constitutionality of waiting periods for gun purchases. This issue presents a fascinating challenge under the Bruen test. While modern social science data clearly shows waiting periods can reduce gun violence, the Bruen test demands a historical analog. The question for courts is whether the practical reality of slow travel and communication in the 18th and 19th centuries, which effectively created a waiting period for any shipped good, constitutes a historical tradition of explicitly codified waiting periods. The outcomes of these cases will vary by circuit, creating a patchwork of constitutional interpretations across the country until the Supreme Court eventually steps in to resolve the splits. Another critical area of legal evolution involves the intersection of technology and firearms law. A fascinating example is the federal H.R. 2189, the Law Enforcement Innovate to De-Escalate Act, which passed the House in February 2026. This bill seeks to reclassify certain conducted electrical weapons, like some taser devices, from firearms under the Gun Control Act to less than lethal projectile devices. This change, prompted by the ATF's determination that the Taser 10 met the definition of a handgun due to its use of gunpowder propellant, would remove these devices from federal firearms regulations and excise taxes. While this specific bill pertains to law enforcement equipment and less lethal devices, it illustrates a broader principle. The legal definition of a firearm is not static. It is subject to agency interpretation and legislative amendment. What is regulated as a firearm today could be deregulated tomorrow, and conversely, devices that were once unregulated, like pistol stabilizing braces, can be reclassified to fall under stricter regulations. This dynamic nature of firearm classification places a heavy burden on owners to stay current with ATF rulings and legal definitions to avoid unknowingly possessing an item that has been redefined as a controlled or prohibited item. Given this complex and rapidly changing legal environment, the legal responsibilities of a gun owner are more substantial than simply knowing how to safely handle a firearm. The first and most fundamental responsibility is to know your status. You must honestly and accurately assess whether you fall into any of the prohibited categories under federal or state law. These categories include, but are not limited to, convicted felons, persons convicted of misdemeanor crimes of domestic violence, individuals subject to certain restraining orders, persons adjudicated as mentally defective or committed to a mental institution, unlawful users of controlled substances, and individuals dishonorably discharged from the armed forces. The new ATF rule clarifies the unlawful user category, but it does not change the underlying prohibition. If you engage in a pattern of unlawful drug use, you are prohibited from possessing firearms. If you are prescribed medical marijuana, which remains a Schedule I controlled substance under federal law, you are still considered an unlawful user in the eyes of the federal government, regardless of state law. This federal supremacy in firearm regulation is a critical and often misunderstood point. State-level legalization of marijuana does not create an exception to 18 U.S.C. 922 G3. The second major responsibility is to understand the jurisdictional nature of gun laws. Your legal rights and obligations change the moment you cross a state line. A firearm and magazine that are perfectly legal in your home state may be contraband in a neighboring state. A concealed carry permit that is valid in your state may not be recognized in another. Some states have constitutional carry, requiring no permit at all, while others may issue permitting schemes where local authorities have discretion over who receives a permit. The Virginia Code, for example, lays out a detailed shall issue process for concealed handgun permits, requiring proof of competence through a variety of certified courses, but prohibiting the clerk or court from requesting any information beyond what is statutorily allowed. Ignoring these differences can lead to criminal charges for carrying a concealed weapon without a license or for possession of a prohibited firearm. This is particularly relevant for travelers. As the Wolford case highlights, a tourist carrying a concealed handgun into a shopping mall in Hawaii could face felony charges unless they have somehow obtained affirmative consent from the property owner, a practical impossibility for most visitors. The legal default, as established by state law, is that you are prohibited from carrying in that location unless a sign or direct statement grants you permission. Another layer of responsibility involves the transfer and sale of firearms. Federal law requires that anyone engaged in the business of dealing in firearms must have a federal firearms license. Private individuals may sell firearms from their personal collection, but they must be wary of straw purchases, buying a gun for someone who is prohibited from doing so themselves, which is a serious federal crime. Furthermore, many states now require universal background checks for all private firearm transfers, meaning that even a sale between two private individuals must be processed through a licensed dealer who can conduct a NICS check. In Illinois, the Safe Gun Storage Act creates a new civil penalty structure for failing to secure firearms, but it also includes provisions amending the Firearm Owner's Identification Card Act to require that even private transfers be conducted through a licensed dealer, with the dealer checking a state database for stolen firearms before completing the sale. This transforms what was once a private transaction into a regulated process with legal paperwork and government oversight. Perhaps the most common misunderstanding in firearms law is the belief that a permit to carry a concealed weapon is a blanket authorization to carry a firearm anywhere. This is unequivocally false. The concept of sensitive places is deeply embedded in American gun law, dating back to the founding era. While the Bruen decision affirmed a right to carry in public, it did not overturn the notion that certain locations can be off-limits. Federal law already prohibits carrying firearms in schools and post offices. State laws add to this list. As we see in current litigation, states are testing the boundaries of what constitutes a sensitive place, with laws banning guns in public parks, on public transportation, in museums, and in establishments that serve alcohol. The Supreme Court's eventual ruling in Wolford may provide more clarity on whether places like shopping malls can be designated as sensitive by default. But for now, the rule is simple. It is your responsibility to know the law of the specific jurisdiction you are in and the specific location you are entering. Posting a no-gun sign may have the force of law in some states, creating a trespassing offense if you carry past it, while in others it may merely be a request. Assuming you know the rules without verifying them is a recipe for legal trouble. Looking at the real-world implications of these legal shifts, we can see a clear pattern. The trend in many states, particularly those with Democratic-controlled legislatures, is toward expanding the categories of prohibited persons and increasing the regulatory burdens on lawful gun ownership. This is achieved through red flag laws, which allow for the temporary seizure of firearms from individuals deemed a risk to themselves or others, through expansion of domestic violence prohibitors, through safe storage laws that create new duties and potential liabilities, and through restrictions on where firearms can be carried. Conversely, other states are moving to preempt local gun laws, expand permitless carry, and roll back existing restrictions. This divergence means that the right to keep and bear arms is not a uniform national standard, but a spectrum of rights that varies dramatically based on geographic location. For the individual citizen, this creates a powerful incentive to be politically engaged at the state and local level. The laws that will most directly affect your daily life are being written in your state capital, not in Washington, D.C. From a constitutional researcher's perspective, the post-Bruen era is a fascinating and chaotic period of legal experimentation and clarification. The text, history, and tradition test has forced both sides of the gun debate to become amateur historians, scouring centuries of legal codes for evidence to support their positions. The government bears the burden of proving that a modern law is relevantly similar to a historical regulation, meaning it must have a comparable justification and impose a comparable burden on the right to bear arms. This is a difficult burden to meet, and many gun control laws have been struck down as a result. However, as the Hemani decision showed, the test is not insurmountable. The court is willing to accept historical analogs that are not dead ringers, but are materially similar in purpose and mechanism. The Hemani and Wolford decisions will provide further guideposts on how close an analog must be. This legal evolution is not happening in a vacuum. It requires careful attention from legal professionals and citizens alike to understand the shifting boundaries of permissible regulation. It is also important to address the concept of confiscation directly in the context of extreme risk protection orders or red flag laws. These laws, which exist in varying forms in many states, allow law enforcement or family members to petition a court for an order to temporarily remove firearms from an individual who is exhibiting dangerous behavior. These orders are civil, not criminal, and typically involve a temporary ex parte hearing followed by a full hearing within a short period. Proponents argue they are a crucial tool for suicide prevention and intervening in potential mass shooting situations. Critics argue they can be obtained based on flimsy evidence and can deprive individuals of their rights without sufficient due process. Regardless of one's perspective, these laws are a form of targeted, temporary disarmament based on a judicial finding of risk. They are not a general confiscation plan, but they represent a significant expansion of state power to remove firearms from individuals who have not been convicted of a crime. The legal battles over these laws often center on the adequacy of the due process protections and whether they fit within the historical tradition of disarming dangerous individuals. Another critical practical consideration is the restoration of gun rights. For individuals who have become prohibited persons, whether due to a felony conviction, a domestic violence misdemeanor, or involuntary commitment, the path to restoring their right to possess firearms is often long, complicated, and uncertain. Federal law provides for relief from disabilities, but the process is administratively burdensome and rarely used successfully. State laws vary widely. Some states have automatic restoration for certain nonviolent felonies after a waiting period, while others require a formal pardon or a costly and discretionary court process. For individuals prohibited under state law due to mental health adjudications, some states, like Vermont, are considering legislation that would make rights restoration even more difficult by applying prohibitions to outpatient treatment and providing no clear mechanism for restoration. Navigating this process almost always requires the assistance of a qualified attorney who specializes in firearms law, as the consequences of making a mistake and possessing a firearm while still prohibited are severe, often resulting in a new felony charge. In conclusion, the phrase new gun confiscation plans is a simplification of a far more nuanced reality. What we are witnessing in 2026 is the ongoing, complex, and often contentious process of a constitutional democracy adapting its laws to meet contemporary challenges while remaining faithful to its founding principles. The ATF's updated rule on unlawful users is a technical correction to align agency practice with judicial precedent, not a new plan to seize guns. The legislative proposals in states like Colorado, Vermont, and Illinois represent policy choices by elected officials to expand the scope of firearm regulation, creating new prohibited categories and legal duties. The Supreme Court cases of Wolford and Hemani are the judiciary's attempt to provide coherent meaning to the Second Amendment's historical test. For the ordinary citizen, the legal takeaway is clear. You must be an active, informed participant in your own legal compliance. You cannot rely on what you heard on the news or what was true last year. You must verify your status under current federal law. You must understand the specific laws of your state and any state you visit. You must understand that your rights to carry are not absolute and are subject to significant location-based restrictions. And you must recognize that the legal landscape is shifting, with new laws taking effect and court decisions altering the constitutional calculus. Responsible gun ownership in 2026 requires not only proficiency with a firearm, but a diligent and ongoing commitment to understanding the law. The Second Amendment may be a constitutional right, but like all rights, Its exercise is governed by a complex web of legal rules that every citizen has a duty to learn and obey.